Welcome to WG University, Weber Gowler's series of educational programs. This is our insurance webinar series. I am Andrew Indek, and I am presenting today with Bradley Baldwin from our Mount Laurel office. If you'd like to view the webinar again, share it with others, or see other WG University programs, please visit the Weber Gallagher website, www.wglaw.com, and you will find copies of this presentation and others under the WG University page. Also, feel free to contact the firm with any questions at questions@wglaw.com. Today's presentation is the pros and cons of arbitrating insurance coverage disputes. So with that, let's get started.
Thanks everyone for taking the time with us. Andy and I basically deal with complex insurance coverage disputes that involve hundreds of thousands of dollars, maybe millions, and a lot of documents. Our practices focuses on commercial general liability, D&O policies, directors and officers liability, EPL, which is employment practices liability, E&O, errors and omissions, and fidelity bonds, which is employment theft. So the focus of this webinar is going to be primarily on those forms of coverage. We're not going to be looking at any UIM, underinsured motorist, uninsured motorist, or workers' comp coverage. So within that gambit, we're going to be looking at a comparative look at courts versus arbitration for resolving coverage disputes.
So what is arbitration? I'm sure most people are familiar with the concept, but just for clarity of the specific types of arbitration we are talking about. An arbitration is a contractually agreed to method of dispute resolution involving one or more neutral third parties or arbitrators who are usually agreed to by the disputing parties and whose decision is binding. Commonly, at least in our experience in the types of complex insurance disputes that we deal with, the arbitrations are resolved by a panel of 3 arbitrators. Each party picks their own preferred individual arbitrator, or plaintiff's arbitrator, or defense arbitrator, and then the parties have to agree on a neutral. The neutral arbitrator is one that both sides can agree to, and that can engender a little bit of dispute, and that will take some time because you're trying to find someone that's going to be fair to both sides. At least you hope they will. The difference between this and a court proceeding, obviously, is when you file a proceeding in court, there is no process or cost, no cost associated with that process, but you have no control over the specific judge that is going to be resolving the case. That is generally, from your standpoint, an arbitrary decision by an assignment judge or a presiding judge in the district in which you have chosen to file your action. So there is really no discretion in your part in finding a judge. So what are the ostensible benefits of arbitration? Well, these are, and I will say, theoretical benefits, because in our experience they're not always the case. But in general, it's supposed to provide for a quicker resolution of a matter. This next parameter, the availability of subject-specific arbitrators, is a real advantage of arbitration. The types of matters we are involved with, which are complex insurance coverage disputes, which are dealing with policies that most people don't have experience, does require a specialized expertise, and the ability to pick an arbitrator who has a specific level of knowledge with respect to that dispute is an advantage. Whereas in court, you are basically left to the whims of an assignment judge, selecting a judge who may or may have no insurance coverage experience, let alone experience with the type of policy involved in your dispute. There is procedural flexibility in arbitration. They are not bound by the rigorous discovery and court rules and discovery tracking that is in court. And finally, at least in theory, there is the potential for reduced attorney's fees, although, as we'll discuss, that is not always the reality.
Arbitration can be useful for some pretty specific forms of disputes that take advantage of the benefits. For instance, collective bargaining agreements. I'm sure everyone's familiar with the Deflategate. NFL NFLPA had a dispute about Roger Goodell's ability to enforce the rules. There is a very specific form of dispute between football leagues, the Players Association, and the NFL. An arbitration panel, really knowing the rules and the ins and outs of that agreement, the collective bargaining agreement, makes that a better forum for that dispute. Another example would be Major League Baseball, a salary arbitration where they're going to assess a player's salary for next year. These are very specific forms of dispute where arbitration lends itself to that versus a court, which, in all truth, they wouldn't even look at that as an actual dispute that would have any business being in court. International business disputes. Looking at the procedural flexibility, sometimes it can be difficult to find a forum, a venue where both parties, if one is from a different country, can agree on what court system they want to utilize. Arbitration gives them that flexibility, and again, they can have arbitrators that are familiar with their industry, as well as the ins and outs of an international currency problem that can be resolved as well. A consumer contract. It's an easier way to resolve what might be a liquidated damage with not a lot of discovery, not a lot of factual disputes, but it's more or less a pretty simple dispute, and it makes it easier and quicker to get that resolved. Also, in certain contracts, they'll have an arbitration provision for maybe a market price or some form of variable that'll govern the contract. They'll have industry-specific arbitrators looking to see what is the correct interpretation of the variable, what market price ought to be used if it's a futures contract for maybe a purchase of, say, oil or any other commodity. In that instance, arbitration can make it easier and it's less expensive for them to argue about the whole contract in court, and it makes it faster for the business to proceed. Now, arbitration in general is an accepted form of dispute resolution. It works. We're not here to beat it up. It's accepted. It's when the dispute is proper, arbitration is great. In many states, they have statutes that govern it. For instance, you have New Jersey, Pennsylvania, New York. Those are the states where our practice is focused. They also have a federal statute that governs how arbitration interacts with the courts. We're going to get into that a little bit later. But the real point of it here is to state that arbitration is an accepted form of dispute resolution, and it works well.
So as we go through this webinar, we're going to talk about a few of the metrics that are the basis for comparison between a judicial procedure versus arbitration. Primarily, you'll see we'll be focusing on the expenses of going to arbitration, the potential joinder of parties and issues that come about as a result of that, the predictability of the outcome, the nature of the resolution, and the availability of appellate review. Generally, the information that the clients need to know, and you, as an attorney, have an obligation to advise, are what these particular parameters and how they will play out during the arbitration. The parties need to understand what is going to be the potential to join other parties to the arbitration if that comes about. How much will it cost down the road, both in terms of the attorney's fees and the arbitration fees? What is the predictability of your outcome? How well can you predict at the outset what your outcome will be once you're done with the final determination of the arbitrators? What is the completeness of the arbitration procedure? Have you really resolved all the issues when it's done? And finally, and a big factor for many when determining whether they're going to choose arbitration or not, is what is your opportunity for appellate review after a determination of an arbitration versus that's available to you in a judicial process.
Starting with the first one, Andy listed, would be expense, and we're looking at court expenses. Now, this really isn't a huge variable. Filing fees are what they are. They're set by the court rules. There are no surprises in there. We've listed for the venues that we work in the applicable filing fees. Motion practice can incur nominal filing fees, $35, $40 for a motion, and of course the court's time, you're not paying for it. So that's a
So just so I'm correct, Brad, when we're looking at these things, we're not really comparing attorney's fees at this juncture. We're basically talking about the third-party expenses of courts or arbitrators.
yeah. Attorney's fees can vary on the nature of the dispute, how contentious it is, what the goal of the parties is. We're basically looking at the cost of having someone resolve the dispute for you. That doesn't include the attorney's fees, that we consider that to be part of the client and the attorney as one with this analysis. There is one other potential expense in court, and that would be if you're sanctioned by the court, which can be a decent amount of money, but you really have to work at that. You need to irritate the court. You need to do some pretty extravagant things to have a court hand down sanctions. So they're usually not too commonplace, and that's not something that you really have to worry about.
I would suggest that's something we try to assiduously avoid for our clients.
Yes, that's true.
So moving on to expenses for arbitration. This is a significant difference between an election to go into court versus an election to go in arbitration. Again, we're pulling out the concept of your attorney's fees, but focusing on what are the inherent costs of going to arbitration. The first upfront cost that is a major component of going to arbitration is your initial filing fee. And that is dependent upon the size of your dispute and the amount in controversy. And in our experience, those can run into the multiples of thousands of dollars simply to file your initial complaint in arbitration, because it's based upon a schedule that the arbitrators have dictated by the amount in controversy. So as opposed to a few $100 filing fee, you're talking about multiple thousands of dollars simply to get the matter into arbitration. Oftentimes, part of the arbitration agreement will have a final fee at the resolution of the matter, which is also dependent upon the amount in controversy and can also, again, run into the thousands of dollars. And this is in contrast to a court proceeding which has no such fees. And then here's the real big difference, is the arbitrator's hourly rates. In the types of matters that we're involved with, it's almost always going to be a three-member arbitration panel. And that's because they're complex matters. The hourly rates for these types of specialized matters, for these specialized arbitrators, in our experience, always runs anywhere from $300 to $600 per hour. And that is because you are looking for arbitrators with very specialized, very highly trained knowledge on specific types of agreements, whether it's a directors and officers policy, fidelity policy, a cyber policy. You need to have the specific experience to be able to fairly adjudicate it. And one of the rationales for going to arbitration is that you can pick people with the specific experience relative to your dispute. That being said, it costs you to get that experience.
Like we've had in the past, even though they're very sophisticated, they don't know everything, and there could be some nuanced points of law that they need to research, that they need to educate themselves about, and so their ability to arbitrate, it becomes more expensive. The more they have to educate themselves, you incur that cost as well. So not only are you paying for their sophistication, but you're also paying for their ability to educate themselves on nuanced points of law, as well as look at the amount of discovery. We've had instances where they were large claims and there are thousands and thousands of pages of documents that we needed to see, or that the insured thought they would be entitled to. We needed to conduct an in-camera review. It's a long and expensive process when you have three sophisticated arbitrators pouring through thousands of pages of documents to see if this is privileged, if this is confidential. It takes time, and they're always charging by the hour. So that's really something you need to keep in mind when you're choosing between arbitration or the court. How many documents are at issue?
Right, and as you just alluded to, you're multiplying that expense by three arbitrators, because the three arbitrators are confirmed on each discovery dispute and coming to a joint decision as to how that discovery dispute will be resolved within the context of the arbitration, and they're all billing you for that process. So therefore the justification that you're getting a more streamlined process more often than not be offset by the fact that you are paying triple hourly fees for the arbitrators to resolve that. If you start bringing in matters such as bad faith, extra contractual liability, punitive damages, these are even more fights that are going to occur between the parties and going to require, again, that resolution between between the parties and to be resolved by you.
Yeah, just as a final point, with regard to coverage disputes, the loss usually has already been incurred, so there's really not a need to expedite the resolution of the coverage dispute if the loss is kind of set in stone, if you will. So when you're paying for that expedited resolution, you have to make the assessment if that's really a cost and a benefit that you need to incur. It's worth it.
So this next point, the strategic concerns regarding arbitration versus judicial proceedings and joinder of parties is a major factor in insurance disputes. And this is something that both parties need to pay special attention to before deciding whether to start a matter in arbitration versus a judicial proceeding. With respect to insurance coverage disputes, there are declaratory judgment acts in virtually every state. There's a federal declaratory judgment act, and those declaratory judgment acts require mandatory joinder of all parties who are impacted or potentially affected by the outcome of a dispute. You cannot proceed through court, or at least you should not, without joining all parties that are impacted by your insurance coverage dispute. That could be additional insurers, that could be other parties that will claim against the insured in the future and seek the benefits of the insurance coverage. That could be other insurers. All of these parties really should be a party to an insurance coverage declaratory judgment act. However, when in arbitration, the only parties that are allowed to be in that arbitration as of right are the signatories to the contract to agree to go to arbitration. And the courts have assiduously held and restricted anyone being part of that arbitration dispute other than the signatories to the arbitration.
Yeah, one of the bases, and we'll get into that later, for modifying or vacating an ARB award, one of them would be that the arbitration panel doesn't have the authority to hand down an award or that would impact someone who's not part of that arbitration agreement. We've come across this in the past where we were representing our client was an insurer, and the insured had entered into a standstill agreement with another insurer that potentially could have provided coverage. And this was, a defense for us. We had an additional insured provision in our policy. However, because that other insurer was outside of the arbitration agreement, we were restricted from asserting that as a defense because it would impact on the insurer's ability to recover, as well as may impact on the person or the entity who was not party to the arbitration agreement, and the arbitrators weren't willing to do that. They thought it was beyond the scope of their authority.
Correct me if I'm wrong, we were dealing with a D&O policy on one end and a fidelity or employee theft policy on the other.
Yes.
And we wanted to bring in the other policy to alert the arbitrators that there was other potential coverage.
Exactly, and they just weren't having it. They thought it was outside of the scope of the arbitration agreement between the insured and the insurer. It didn't include the other insurer.
So why is that important for you to consider right off the bat? So if you have a policy that's covering an insured and they may have other coverage out there, and you are going to go through an arbitration to a resolution where an arbitrator is going to make a determination about your coverage obligations in a vacuum without considering the availability of other coverage and other policies, it's essentially alleviating or eliminating your ability to argue about allocation, whether there's excess carriers, whether you are excess or primary over other policies, whether there's some pro rata allocation between your policy and another policy, whether there are additional insureds or third-party beneficiaries which have a right to coverage under the policy, none of those things are going to be resolved by the arbitrator because none of those people are parties. And the courts have frankly said, well, that's the way arbitration works, and if there are inconsistent results, we're willing to live with that. And so that's a factor you absolutely must know before you start your arbitration.
So when you're paying for that resolution, there still may be litigation down the road to resolve other issues, the allocation of pro rata.
Which you're dealing with an already determined resolution by an arbitrator or arbitrators.
Like Andy said when we started out, one of the key points of educating your client is letting them know what the outcome may be, or give them an educated guess. I mean, there are no guarantees. With courts, it makes it a lot easier. They have to follow the precedent and the unambiguous terms of the policy. If you have a good defense, if you know certain exclusions, policy provisions have been interpreted in certain ways, and the case law is clear, it helps you educate the client and allow them to have more of a, I guess, I don't know, prescient view, but you kind of know what's going to happen. That's not really the case with the arbitration panels. While they're bound to give you an independent and deliberative decision, or their process is going to be deliberative, they're not really bound by the judicial precedent. They can invent or come up with their own rationale. And that makes the outcomes in arbitration a little more difficult to predict. You may think you have a slam dunk defense applying an exclusion, or maybe a claim was never asserted. The arbitration panel will take more of a holistic view of the entire controversy and try to reach a compromise resolution, and that can make it difficult to really predict what the outcome is going to be.
And so dovetailing on the predictability of the outcome is the predictability of discovery. Again, in concept, arbitration is supposed to be a more streamlined process for getting through discovery. In theory, there's supposed to be more limited discovery. In practice, if the parties really need the discovery to resolve the dispute and the arbitrators agree, they're going to allow most discovery. They're going to allow depositions. They're going to allow document production. They're going to allow interrogatories if you make a compelling case that you need that discovery. And again, if there's any disputes about that, well, then you're dealing with the arbitration panel billing you for making that resolution. But in a court, there are fairly circumscribed procedures for discovery. It's in the court rules. There are fixed discovery deadlines. There's well-established precedent about what discovery can and can't be taken in the judicial procedure. And as Brad was alluding to, that's more of a nebulous, amorphous process in arbitration than it is in court. On top of that, that factor can result in real prejudice, especially to insurers, if there is a bad faith punitive damages or extra contractual liability component of the claim. And Brad has become somewhat of an expert in our quest to educate the courts about bifurcating discovery on bad faith and extra contractual liability. We've had multiple cases where the insureds are seeking information through either interrogatories or document production, which is clearly geared towards bad faith, although it may not be obvious on its face. So maybe Brad can talk about some of the examples we looked at.
It's just in the courts, usually there's an obligatory bad faith claim that'll follow any type of claim for coverage, and you don't fault a insured's attorney for putting them together because they just want to make sure they get their pleadings complete. However, they inevitably will ask for the claims file, the underwriting file. They want to depose claims handlers. They want to depose managers for our client, and really that has no bearing on the existence of coverage, which boils down to a policy provision and the facts that articulate the claim. And it's really just putting the policy next to the claim and seeing if there's coverage. How our client or an insurer treated that claim is of no moment if there's no coverage.
Right, and the courts, at least in the jurisdiction that we deal with, have universally ruled that there is no entitlement to discovery relative to bad faith until the court has made a determination about whether the insured is entitled to the coverage in the first place, which is the basic component of the dispute. And anything, as Brad alluded to, where you see that type of request, we want to see your claims handling notes. We want to see any drafts of prior coverage decisions. We want to see how your claims handling manuals are. That all speaks to bad faith. That all speaks to extra contractual liability and punitive damages, because you basically want to see whether the insurance carrier did something contrary to their own experience or parameters. And we have had so far complete success every time we've raised the issue of having courts say, no, we're not going to get that discovery up front. We're going to wait for the coverage determination to be made. The one instance where a trial court didn't agree with us, it was summarily reversed without even the need to file further papers at the appellate level, and ended with an order saying that discovery is stayed.
Conversely, in the arbitration, their default is usually give us everything. They want to see all the information. They consider themselves to be experts, and that's really why you hired them. So with that expertise, maybe there's a little bit of an ego as well, and they think they're going to be able to fix this. They're going to figure it out for everybody. So give me everything. We want to see everything to make sure you didn't do anything wrong. And obviously, like we discussed earlier, that can increase discovery costs, and it can also have an impact on the nature of the resolution.
And I think the courts also recognize that that type of discovery is inherently prejudicial to the insurers, and arbitrators are only human, and they're going to see things in the claims handling file that may not be all that flattering to the insurer. You just don't know. But at the end of the day, it's irrelevant if, as a matter of law and contract, there's no coverage.
True. In court, but an arbitration panel will consider, absolutely, and it can mold their award if they grant one, and that kind of goes to the nature of the resolution. Now, usually in courts, well, in general, a coverage dispute is a binary decision. You either get it or you don't. There are instances where you may be allocating defense costs, doing pro rata shares. That's really not the type of issue we're talking about today. It's whether there is or is not coverage, and there's really no middle ground. There's no splitting the baby there. So in the court, it doesn't care if there's a clear winner and a clear loser. It's not going to compromise. It'll follow the law, and it'll follow the clear and unambiguous terms of the policy. Conversely, an arbitration panel is going to seek to compromise. As much as they are going to follow some precedent, they're also a business, and they're providing a service for both the plaintiff and the defendant's side. And arbitrators don't want to get branded to be a plaintiff arbitrator or a defense arbitrator and get pigeonholed, because it really limits the amount of business they can take on. It's their livelihood. You don't fault them for it, but it's a consideration to keep in mind. And with regards to bad faith claims and the amount of discovery, you need to prove that you are entitled to coverage in the court before you get bad faith discovery, before you can pursue a bad faith claim. Arbitrators won't look at it that way. They're going to consider the whole ball of wax. And so if the ball of wax is a little bit bigger, it's not just coverage, now it's coverage and bad faith, then the compromise resolution is going to be larger as well. So let's say it might be a coverage claim for $1 million and some bad faith damages of $250,000. Well, if they're going to split it, it's going to be splitting not the $1 million, it's going to be splitting the $1 million too. And so when they split the baby, it's a fatter baby. And so that's something to keep in mind, the fatness of the baby. Additionally, there's one other point. If you're representing an insured, or you are the insurer, or you're the insurer, and there is a really cognizable bad faith claim, and there's the potential for significant extra contractual damages, then that splitting can also be beneficial, because they may not award a whole lot of punitives. They're going to look at the coverage as well as the extra contractual damages, and it might go in your favor that way, because it's going to kind of compromise your the amount of damages that you could be subject to.
Yeah,
so
you're right.
It cuts both ways.
And so what you're what Brad's basically getting to is this is an upfront evaluation that you need to make, assuming you have the choice not to go to arbitration. Brad's initial comment that this is insurance coverage disputes are binary. There's either coverage or there isn't, and any carrier that is careful is going to either run their coverage position up through the chain of command, or they're going to get outside counsel to give them the best advice about what their coverage position is. Once you've come to that decision, you hope the rationale has been that we're correct and we're not subjecting ourselves to bad faith, and we, based upon the precedent and the jurisdiction we're going to be in, we should prevail on this issue because it is a straightforward, whether it's the claim wasn't made within the time frame of a claims-made policy or there was an absolute exclusion which has always been upheld, and you're going to make that binary decision that you should win outright. And to go to court on that, you will, unless you get a rogue decision which is subject to appeal, which we'll talk about in a minute, you should get the proper outcome. Whereas if you're less certain and there may be some risk out there and it can't be resolved up front, the arbitration might be the way to go because you're in effect going to get an arbitration or settlement through arbitration.
Yeah, it's a good way to look at it. It's just a compromise resolution.
So as what I was alluding to before about the review of a judicial determination, there is obviously a fixed process, a well-known process for reviewing judicial decisions. You have a right, once a trial judge or a motion judge has made a dispositive decision, to go up to the appellate reviewing court. They are bound to review the law against the precedent in the jurisdiction. They can review mistakes of law. They can review mistakes of policy, all types of things like that, which, as Brad will talk about in a second, you're not going to get in an arbitration review. It's based on known precedent. So again, up front, when you make your determination, should I go to court because I have known precedent and a known process, this is what you're looking at. I know I should be correct on the law. We've handled cases where it's a claims-made policy. The claim was made outside the policy. There's no dispute in our mind that we are absolutely correct, and we're advising our carrier that you face virtually no risk. I mean, obviously there's always some risk, but there's no guarantees. But this is as close to a slam dunk as you're going to get, and that's the type of case we want to bring in court because we're certain, or relatively certain, of the outcome. We're not in the business of subjecting our clients to bad faith or other types of decisions. So when we're that confident, we want to be in court.
So if you find yourself on the wrong side of an arbitration award, you're pretty much stuck. I mean, it is a high hurdle to overcome. Courts are loath to overturn an arbitration award where the parties previously agreed to have their dispute resolved by a binding arbitration. It defeats the purpose of binding arbitration, and just sending it back to court doesn't really serve a purpose. On this slide is an example of a statutory the codification of how to vacate an award in New Jersey. And if you look at it, a lot of it's procedural. I'll point you out to the first one, where it's corruption or fraud. That's a really high hurdle and difficult to prove, to show that there was collusion between arbitrators and one of the parties to the arbitration. It almost never happens. I mean, in the commercial arbitration setting, a lot of the arbitrators are either judges that are retired, well-known attorneys that have an expertise, and they got their good reputations because they're fair, they're ethical, and they're honest. So it almost never comes up, and the odds of it happening are slim to none. With regards to number one, the last part of that, undue means, is another really high standard to reach. Undue means, the legal standard, I'll read it to make sure I get it correct, the legal standard to vacate an arbitration award requires a showing on the face of the award that the arbitrator meant to decide according to the law and clearly applied the wrong legal rule. So it's just such a fundamental error. It's not a misapplication of the correct law. It's using the wrong law when they intended to use the right law. So it's a really fundamental error. And again, you need to almost get an arbitrator to admit that they applied the wrong standard to be able to implement that. So again, if you get stuck with a bad arbitration award, it's hard. It's almost impossible to vacate. Now, there's also a common law method of vacation that really doesn't find as much application anymore now that the other ways to vacate an award have been codified. And but this method is a manifest disregard for the law, and you guys can read it at your leisure. But basically, what it comes down to is an arbitrator knows the correct law, looks at it, and just decides to ignore it and not follow it. Again, this is very difficult to show that the arbitrator is aware of the correct law and then nevertheless made a conscious choice not to follow it. High standard to prove, and more than difficulty to prove it, it just doesn't happen that often. So again, the form of appellate review of an arbitrator's award, it's difficult to get, and it really doesn't exist to the same manner that it would with regards to a court's ruling where you get a review of that by right.
Yeah, and I think I would chime in, and Brad would agree that that last piece, that manifest disregard of the law, is probably the one component that you see the most when people try to vacate an arbitration award. You know, they conflate the manifest disregard of the law with
error,
with just a simple legal error, which would be the judicial standard. And they try to suggest that by whatever determination they made, it basically was a judicial error, and they phrase it as a manifest disregard of the law. And again, the courts have been almost uniform in saying that's not the standard.
Yeah, it's not giving even weight to evidence, applications of certain I mean, it's just such a high standard to get. It's difficult.
And I'll give you two anecdotes from cases Brad and I have experienced, or which we're aware of within our firm, to give you an idea of why we're saying what we're saying about how difficult it is. One is we had a case where an insured obtained an arbitration award and was seeking coverage for it, and their counsel wanted to, or the insured wanted to move to vacate the award, and their counsel basically withdrew as counsel for the insured, saying it would be unethical, frivolous, and in bad faith for me to file an application to seek to vacate the award based upon a legal error or something along those lines, because counsel, who was a good counsel, recognized that this is something the courts simply do not grant, and did not want to subject themselves to that type of potentially even sanctions for bringing a frivolous application. On the flip side, one of our other partners in the insurance and reinsurance group actually did obtain a vacating of an arbitration award in a reinsurance context, and in the very rare circumstance where there was a conflict of interest and colluding between one of the arbitrators and the adversary, and it was such a momentous decision that it was instantly across all of the insurance publications and published, because it almost never happens, and it was such a rare circumstance that it made big news that actually happened.
And dovetailing with that, looking at modification, again, it's almost a procedural fault if there's a mathematical error. If the form of the arbitration award is difficult to interpret, hard to implement, these are the things that will allow you to modify an arbitration award. However, the decision itself, that one party prevailed over another, will stand, so it's only modifying the award. So it really doesn't give you any relief as to the actual award itself or the resolution.
So what do you make out of all this? Brad did mention some of the circumstances where we've found it is beneficial to go to arbitration. There are definitely circumstances where it can benefit you. In our experience with respect to the types of matters we're handling, however, and the circumstances at which we're getting to that point, our opinion is, with respect to these types of complex insurance disputes, you really should seriously consider having these filed in a judicial form rather than an arbitration form, especially when you know the likelihood of the outcome that you're going to face. That concludes our webinar for today. If you have any questions about today's presentation, please email us at questions@wglaw.com, or you see Brad's and mine email address up there, aindec@wglaw.com and baldwin@wglaw.com. You can also learn more about this program and all other Weber Gallagher events at www.wglaw.com/wg-university.
Yeah.
Thank you for your time,
Yeah, thanks
and
a
I
lot.
hope you find it informative, and always feel free to reach us with any questions.